Let's begin what's trending with an update to the Free Nnamdi Kanu protest on Monday, where despite court orders, protesters led by activist Omoyele Sowore trooped out to demand the release of the leader of the indigenous peoples of Biafra. Well, on Tuesday, a magistrate court ordered the remand of Aloy Ejimako, one of the lawyers representing Nnamdi Kanu, in Kuje prison. The police arrested Ejimako after he joined protesters demanding Kanu's release and charged him alongside 12 others with various offenses, including criminal conspiracy, disobedience of a lawful order, inciting disturbance, and disturbance of public peace, contravening sections 152, 114 and 113 of the Penal Code law. This development has escalated the controversy surrounding the protest, while legal observers note that while lawyers have the constitutional right to peaceful assembly, their arrest during the protest they participated in adds another layer of complexity to an already contentious case involving freedom of expression, the right to protest, and due process. Well, activist Omoyele Sowore, in response to this detention, actually put out a post on X, and he wrote, "It is unfortunate that the Nigerian Bar Association has remained quiet regarding the unwarranted and unjust detention of Nnamdi Kanu's lawyers, Aloy Ejimako and Barrister Okereke Kingdom Nnamdi. President Afam Osigwe, what is going on? Hashtag Free Nnamdi Kanu now." In the meantime, the Center Against Injustice and Domestic Violence has called on the Nigerian Bar Association to take immediate disciplinary action against Aloy Ejimako for alleged professional misconduct. In a statement, the group condemned the lawyer's appearance at the protest ground, describing it as a clear breach of professional ethics and a violation of Rule 33 of the Rules of Professional Conduct for Legal Practitioners 2023, which deals with sub judice statements. And according to the rule, and I'll read this statement in part, it says, a lawyer or law firm engaged in or associated with prosecution or defense of a criminal matter shall not, while litigation is pending, make or participate in making any extrajudicial statement that is calculated to prejudice or interfere with the fair trial of the matter, adding that the law expects that lawyers argue their cases in court, not on the streets, in protest grounds, or on media platforms. I mean, Vimba, I'm coming to you. Mr. Ejimako's participation in this protest is, they say, is tantamount to trying to sway public opinion and, by extension, the court's view on the matter still under education. I mean, your thoughts on, some of all of these things that I've unpacked before, we discuss on the issue of Nnamdi Kanu as well, because I believe that he has also filed.
Yes, very complex issues. And I think in this instance, I always like to say two things can be true at the same time. The first issue is dealing with the incarceration of the lawyer and the other group of activists. Now, when you look at that FIR report and the issues that they are being indicted for, there are a number of concerns. The number one concern being people are saying that, but this group also included Sowore himself, but Sowore is a free man, and the other 13, I believe, are in prison. So why is there separation between those who have been arrested if they were all together in a group and alleged to have all committed the same offense? Why is there this selectivity? So that means that clearly the playing field is not level. The rules are not applying equally, and many people are even challenging and contesting those rules to say, well, is this really what transpired? Were they really causing public disruption with their protest? Besides the fact that they did stay within the limits prescribed to them, when they tried to go beyond those limits, the police acted, and they were peaceful in their execution. However, another issue that I brought up earlier that I'll bring up is this issue of of chanting war songs, and I think we have to be careful now with where we're going. I drew parallels with the case of Julius Malema in South Africa, who was taken to court over chanting a war song. If you remember, he has a song called Kill the Boer, and he says that it's not an insightful song because it's a remnant of their liberation past. So we now need to start having a conversation in Nigeria about whether chanting of war songs that are remnants of a struggle of the past do constitute a public disruption in some form or the other. In South Africa, it was ruled to have been within the constitutional right of any activist or advocate to chant any war song they want. Now it's set for the Nigerian law to set their own precedent on this issue. Now that's on one aspect. On the aspect of sub judice, the rules are clear. This man was on the streets advocating for and vocalizing for a case that should have been in defense as of that point. Of course, we've seen a number of issues that have come up with regards to delaying going into that defense. But at this time, I think that we need to focus our attention to the defense, because the prosecution have rested their case, and it's now up to Nnamdi Kanu to put forward his own defense. I know there are other developments that you'll come to, but and it's now not only is it up to him to put forward his defense, but it's also up to the public, civil society, to hold the judiciary accountable to ensure that his defense is treated fairly, it's given in a fair environment, and that he has access to all that he needs to be in order for him to provide a thorough and robust defense for himself. I think I hope I've dealt with many of the substantive issues, but yeah.
I mean, in terms of Ejimako being, detained in Kuje and all of that, you would wonder, I mean, he's a lawyer, shouldn't he have known the rules? But I'm sure that there'll be other, lawyers that would actually come and argue his case as well as to whether or not he had the right to protest.